Thank you very much, Naomi, and welcome everybody. It's wonderful to see so many participants, and I trust you'll find this a very useful and informative webinar. Let me start by very briefly introducing myself. I'm a solicitor and a partner at Marks & Clerk. I studied chemistry before I converted to law and qualified way back in 1998. And ever since then, so 24 years since then, I have been specializing in patent litigation in all technical fields. Thomas will, of course, be able to give a very brief introduction to himself when he, in due course, but I'd just like to mention that he's a fully qualified UK, German, and European patent attorney, and that leads to how we plan to split up the webinar, which is that Thomas will be best placed and perfectly placed to talk about everything to do with patent prosecution issues, and my forte will be more on the court structure itself and the litigation angle. I did request control. I will do that again and just see if it's working, because I just, unfortunately, on my keyboard, having pressed the keys, it didn't work straight away. So let me try and do that again. Here we are. Let's hope that's right. So here's a summary of the contents of the webinar. I'm going to start with an overview and a bit of a background about the Unitary Patent and the Unified Patent Court. Thomas will then cover the Unitary Patent in much more detail and look at the all-important opt-out rules, which are something that we're all going to have to get very used to in the next few months. And finally, I will then look at the structure of the Unified Patent Court itself and look at some of the more important and interesting aspects of the procedure that is going to apply to cases that are brought before it. So to start introducing the new Unitary Patent and the Unified Patent Court, the most important thing is to look at what we currently have. And this is the general system under the European Patent Convention. And there are around 40 plus countries that are all contracting states of the EPC, and nothing changes in that respect so far as the European patent system is concerned. European patents will be obtained in exactly the same way as they are now. And what that means is that when the European Patent Office grants a patent, the applicant has to decide in which countries to validate that European patent. And as the slide here depicts, effectively the patentee obtains a bundle of national patents, which then has stand or fall in each jurisdiction on its own. So that if the UK court revokes a patent, and that only applies to the European patent validation in the UK, that decision may well be persuasive on courts of other countries, but it is not binding on them. And it is open to courts of different countries to reach different decisions on infringement and validity. If we look at the new system, much of that stays the same in that on grant, the applicant still chooses where to validate the European patent. And for countries that are not participating in the UPC system, but are parties to the European Patent Convention, such as, for example, the UK and Norway and Spain, patents will be validated on a national basis exactly the same as they are now. However, for countries that are participating in the UPC system, the applicant will have a choice. The applicant can either validate in a number of national jurisdictions just as before, or the applicant can choose to validate the European patent as a unitary patent. And what that will mean is that across all the participating countries in the UPC system, that there will be a single unitary patent, and that will be litigated. It will stand or fall or be surrendered and renewal fees will be paid as a single patent that covers multiple countries. So if a little bit of the background now to how the UP system was created, to start with, years and years and years of negotiation. It's been going on for decades. And eventually, after a lot of argument, language was a huge problem, for example, and we had the three official languages of the EPO: English, French, and German. But Spain wanted Spanish to be an official language. Italy wanted Italian to be an official language. The other countries didn't want to have so many languages. And in the end, the European Union invoked what they call the enhanced cooperation procedure to enable everyone except Spain and Italy to proceed to negotiate without them, which is an interesting idea of enhancing the cooperation, but it meant excluding the people who wouldn't agree. But that led to the UPC agreement in 2013, and there are three main instruments involved in that. There is the UPC agreement itself, which is an international treaty between the participating countries. Alongside the UPC agreement, there are two EU regulations, and one of those is to do with the unitary patent and establishes that amongst the participating countries, the European patent can have unitary effect across their territories. The other EU regulation concerns translation requirements. Who is part of the system? Well, originally the UK was part of the system. The UK is not now. That's a consequence of the UK leaving the European Union. This leaves 24 signatory countries. They are all EU countries, and in fact, it means all of the existing EU countries, but not Spain and not Poland and not Croatia, all for different reasons. As Spain originally decided not to take part because of the language concerns that it had, Poland because of an economic analysis, and Croatia simply was not a member of the EU at the time and has not yet signed up, and it's not clear whether it will in due course, but it may well do so. Now, the agreement is what establishes the court, and I will come back to this later when we look at the court structure, but there is a very important reason why this was not set up by an EU regulation, and that is all to do with the jurisdiction of the Court of Justice of the EU. The intention of the parties is that patent disputes, the vast majority of them, should be resolved without references to the Court of Justice of the European Union. And to try and achieve that, it required the court to be established outside EU law. Lastly, there are very, very important transitional provisions, and these are to do with the concurrent jurisdiction of national courts and the UPC in the participating countries, and also to do with the ability to opt out national, when I say national European patents that are not unitary, for where the proprietors do not wish those patents to be part of the system. That's very, very important, and we will be covering that in a lot of detail. The court is going to have jurisdiction over unitary patents, first of all. So European patents that have been validated as unitary patents. The only court that will ever litigate the validity and infringement of unitary patents is the UPC. I say only that there will be very rare exceptions when we're looking at multi-jurisdictional proceedings and perhaps with preliminary injunctions, but the principle is that unitary patents will be litigated in the UPC. The UPC's jurisdiction, though, does not end there. The UPC will also have jurisdiction where European patents are validated on a national basis in countries that are participating in the UPC project, the UPC will also have jurisdiction over those patents. And ultimately, after the transitional period comes to an end, so far as those participating countries are concerned, all European patents, whether unitary or validated on a national basis in those countries, will be litigated in the UPC. The result of that is that a single action in the UPC can take effect across multiple jurisdictions. And the UPC will be able to grant injunctions, it will be able to determine infringement and therefore damages, accounts of profits. It will be able to determine the validity of European patents, and it will also be able to hear declarations of non-infringement in respect of European patents. Finally, the supplementary protection certificates that are granted in respect of European patents that fall within the jurisdiction of the UPC will also themselves be within the jurisdiction of the UPC. The court will be able to award costs to the winning party. The way that will work is that each action is going to be given a notional value, which the court will have to decide if presumably if the parties haven't agreed, and that will set a cap on the amount of cost that a losing party will be ordered to pay to a winning party. Looking at the current proposals, which are some years old and to my knowledge have not yet been formally adopted, the maximum costs when you had cases around 50 million euros in value, cost shifting could be 2 million euros, though the court had the discretion to lift that to 5 million euros. There are also, very importantly, for parties wishing to bring actions in the UPC, fixed and value-based court fees that will apply. And these can be quite significant. The starting point is that for infringement actions, the court fee will be 11,000 euros as a fixed fee, but then there is a value-based fee which could range, for example, to an additional 4,000 euros if the action was valued at 1 million euros, or for the most expensive or the most high value actions, 50 million or over 50 million euros in value, the court fee could reach 325,000 euros. So court fees can be very significant in high value actions. Revocation actions, the proposed court fee is a flat rate of 20,000 euros. Now, we have all got very excited about the unitary patent and the UPC again, because the provisional application period commenced on the 19th of January of this year. There had been, following the agreement, the UPC agreement, and that being signed by all the participating countries, it was thought that things might move ahead very, very quickly. That all stopped because of some constitutional challenges in Germany. They have been resolved, and there is a protocol to the UPC agreement which allows the agreement to take provisional effect, certain parts of it, in order to allow the court to actually employ judges, arrange its IT systems, and take all the necessary steps that you actually need to have a functioning court so that it can hear cases as soon as the UPC agreement itself is formally brought into effect in its entirety. Now, so the provisional application period has now begun. It means that the UPC exists as a legal and an international institution. The judges are going to be appointed. The IT systems, as I said, will be completed. It means that there is now a formal administrative committee, which is very important for the functioning of the court. Before the provisional application period started, there was a preparatory committee that was making draft rules, draft decisions. It's the administrative committee that will actually formally issue the rules, such as the rules of procedure, and formally make decisions such as rules relating to qualifications necessary for lawyers and attorneys to have representation rights. Now, the meeting of the administrative committee, the very first one, took place just 2 days ago. And the news report from that was that it has formally adopted the rules of procedure. It has made a declaration on representation rights. As I speak today, I haven't been able to find out precisely what it has decided, but that will no doubt be published very soon. And for now, I'm assuming that it is adopting decisions in line with the proposals that were originally made by the preparatory committee. The expectation is that the provisional application period may last around 8 months. There's no firm deadline. It's going to be as long as it takes to get everything ready, because the last thing anybody wants is for the court to officially open its doors to cases, but then find that the IT system collapses and it's not working, or that the system for opting patents out of the jurisdiction of the court isn't working. So, but when everything is ready, all that needs to happen is for Germany to deposit its instrument of ratification of the UPC agreement. Germany has already passed the legislation through its own parliament, so the ratification is effectively done. It just needs the formality of depositing the instrument of ratification, and so Germany can do that whenever it wants, and it will hold that back until everyone is ready. As soon as it does so, a very important sunrise period will start. This will last 3 to 4 months, and during this period, patent proprietors will be able to file opt-outs of their European patents, their existing ones in particular, if it does not want those patents to be subject to the jurisdiction of the court. The EPO will also be able to accept requests for unitary protection for new European patent applications that are proceeding to grant, and there will also be the start of the registration for lawyers and attorneys to be official representatives before the court. Once the sunrise period ends, the UPC will be fully operational and will be accepting cases, in particular infringement and revocation cases. However, transitional provisions, which we will discuss in a lot more detail, will apply for many years. Thomas, over to you now.
Excellent, thank you, Graham. Now, thank you also for the introduction. As Graham said, I'm a European patent attorney, also qualified as a UK patent attorney and the German patent attorney. I've got over 20 years experience in this, so hopefully I'll be able to guide you through the unitary patent side of things halfway cogently. Now, what I wanted to start out with is an analysis of the countries that are actually involved. There are many countries in Europe, and I guess how they contribute or not may well be a little bit confusing. Now, the blue ovoid that you see here, that represents all of the European Union member states. Now, the first thing I'd like to highlight is that the blue ovoid is much smaller than the red one representing all member states to the European Patent Convention. That means really, or maybe you conclude from this already, that in as far as the European Patent Convention is concerned, in as far as the work with the EPO is concerned in particular, there is no change whatsoever. The UP and UPC does not change the interaction with the EPO or the way you actually get European patent protection. It's what you do with it afterwards that is changed by this new model. Now you can also see a dark gray and a light gray ovoid. The light gray ovoid relates to all of those countries that actually participate in UP and UPC. You can see you can see that, for example, Germany has said they would participate. Graham's mentioned them already, and Ireland, but they are not in the dark gray ovoid of countries that actually have deposited their instrument of ratification. It's only those countries that have deposited their instrument of ratification that will that UPs will extend to. So at the moment, for example, Ireland isn't covered. The minute Ireland deposits their instrument of ratification, they are covered. Now that's an important thing to realize, because ultimately what this means is that there will be different generations of unitary patents, depending on when the patent grants, of course, and depending on which countries at the date of grant have ratified the UPC agreement. Now, Germany, I mentioned that, James mentioned it as well. They're a bit of an outlier because Germany's ratification is required for the UPC to start in the first place. They are deliberately holding back to allow for time for the systems that underpin this whole new construct to be constructed. So Germany will be in from the start. It's a condition for that. It's just that they're holding back for now. Now, we will have on our website a map that shows when the individual countries have exceeded or have deposited their instrument of ratification, simply to provide a simple tool to keep track of the geographic scope of unitary patents. Now, if you decided you wanted a unitary patent, how do you go about that? Try to illustrate this here. Yeah. So as I said earlier, nothing changes in the prosecution of a European patent. You file a European patent application with the UPO. You prosecute that to grant in exactly the same way you would right now. There is then a time window from the date of grant to 1 month after grant, where you can actually file a request with the EPO saying, give me a unitary patent, please. And if you do that, and the request is proper, then you get a unitary patent for that. But it should be emphasized that you don't actually have to get unitary protection based on your granted European patent. If you don't like it, you don't have to. And then you very simply validate your European patent in the countries of your choice in the way you do right now. Now, what's important to note here is that irrespective of whether or not you get a unitary patent or national validation in UPC member states, the UPC will have jurisdictions over those. And that doesn't just apply to validations you make in the future. This applies to validations you've made in the past as well. We'll come back to that point in some detail in a moment, because it is a very important point. Just to highlight, though, the jurisdiction of national courts remains the same for patents you've actually obtained nationally. For any country, it doesn't matter if it's a UPC member state or not. And for non-UPC member states, the national courts also have exclusive jurisdiction. As I said, there is a 1 month deadline for filing a request for a unitary protection. And in addition, you actually have to file a translation of the granted European patent. Now, let's talk about those translations in a little bit more detail. Most European patent applications are in English, so that I think that's almost the default state. And for all European patents granted in English, you need to provide a full translation into another official EU language. If the language of proceedings is French or German, as happens in a minority of cases, then the spec by default or by definition has to be translated into English to get a unitary protection. Now, last time this topic became very hot, we had quite a few questions along the lines of, well, actually, what type of translation do I need to file? Could it be, well, does it have to be a human translation, or could it be a machine translation? Now, the rules don't explicitly deal with this, but what they say is, as I said here, that the translation will have no legal value and it will be for information purposes only. Put in other words, if a court was to deal with a validity action or an infringement action, they would actually base their decision or their considerations on the text as granted by the European Patent Office in the language of grant, so mostly in English. So whilst there is no legal value associated with the translation, one has to be careful, though, because imagine a situation where you file a translation that is maybe a little bit inaccurate in one of the other EU languages, and then somebody came along, an alleged infringer came along and said, well, okay, but I didn't have a chance of actually understanding that patent because the translation was bad. That wouldn't help them in terms of the findings of the court, the consequences they suffer. They still have to comply with the original text of the patent, but maybe when it comes to damages, they may well be reduced by the court simply because of this argument that the translation was bad. So it's a balancing act that we have to meet here. Going to the geographic scope of the UP. Now, obviously, a unitary patent can only cover those countries that participate in the UPC agreement. Now, those patents will be listed if the UPC. If the unitary patent is granted for at a time where a member state hasn't actually deposited the instrument of ratification, then the unitary patent cannot cover that member state. Let's go back to the example of Ireland. If a unitary patent is granted before Ireland actually deposits the instrument of ratification, then the geographic scope simply excludes Ireland. You can still validate separately in Ireland, and that's what you have to do if you want patent protection for Ireland. Now take a situation where Ireland then later on deposits their instrument of ratification. What this doesn't mean is that the old UP that you've got then suddenly covers Ireland as well. It doesn't. The territorial coverage of the old UP will not increase. If a patent grants later and you want unitary protection, then Ireland is covered. But once the territorial scope is set, it will not change irrespective of later depositions of instruments of ratification. In other words, there will be different generations of unitary patents. We tried to be helpful here and include a map of the territorial coverage. As you can see, this is a map of the participating member states. It's slightly inaccurate in that Poland has actually declared they're not participating, so this should really be gray. But the purpose of this map really is to show that there's a difference between participating member states and member states that have ratified. The number of dark blue countries will increase as time goes by, and so will the territorial coverage of a unitary patent that you can get from time to time. We have created a tool on our website that tracks this. At the moment, of course, there is only one date of accession, and that will be when the UP actually comes into force. But as things progress afterwards, the dates will differ. So hopefully that is a useful resource for your use. Now, it is entirely conceivable. In fact, it's almost inevitable that people might think, okay, I want a unitary patent, but as said earlier, unitary patents are only available after the UPCA has come into force, i.e. not now. So what do you do if you think, well, actually, I want a unitary patent, but I can't get one yet because, simply because the UPCA is not in force. The EPO has considered this point, and they said, okay, we will allow you to request delay of grant so that the patent grant after the UPCA comes into force and you can get unitary protection if you so want. But they will only allow you to file that request after Germany has deposited their instrument of ratification. It's shown here as May 22. We don't, of course, know when that will be. I think May is actually sort of quite optimistic. I suspect it might well be more in autumn. But regardless of that, only after that date can we request a delay of grant. Now, please, if you say, well, I still want unitary protection, even though it's not possible to make this request for delay of grant, it is entirely possible to delay grant based on our own actions without the help of the EPO. In other words, if you're interested in this, please do come and talk to us, and we'll make sure we actually analyze the situation you're in and make sure we take the right steps. Now, what if you are not interested in UP? Well, as I said, you don't have to go for unitary protection. You can go through national validations as you do right now. But please be aware, as I said earlier, these still fall under the jurisdiction of the UPC. So maybe that's a positive, maybe that's a negative. We'll talk about how to deal with this in a moment. If you really, really want to avoid the jurisdiction of the UPC long term, you ought to consider separate national filings, although there are other ways of going about this. I'll come to those in a moment. Now, let's look a little bit at the jurisdictional issue. Now, the two graphs that you see here, this is the state we're in at the moment and have been for many, many years. And this is the future state. But please note, this is not the state that the UPC system will adopt in the immediate future. This is the state it will adopt after a transition period that is presently set for 7 years from the start of the UPC coming into force. In those 7 years, there will be transitional provisions. Those 7 years can be extended to 14 years. So we're looking at quite a long transitional period overall. Looking quickly at the current system, it doesn't really matter if you get a patent validated nationally through the EPO, or if you get national patent protection through the various national patent office. The only courts that have jurisdiction, exclusive jurisdictions, are the national courts. Now, this is about to change. 7 years or 14 years, depending on the extension, after the UPCA has come into force, the UPC will have exclusive jurisdiction not only over unitary patents. I guess that is almost self-explanatory, that the UPC will have exclusive jurisdictions of the unitary patents, but also over your national validation of European patents in UPC member states. That's a super important point to note. National validations in non-UPC member states still are exclusively dealt with by the national courts. And if you wanted to escape the UPC jurisdiction, even in UPC member states, then your only choice after 7 years are national patent filings. Right, but that's only in 7 years' time, right? So let's have a look at the transition provisions. In the transition period, the jurisdictional arrangement is like this. So again, UPC, exclusive jurisdictions for unitary patents, self-explanatory, I guess. The national courts are also still exclusively responsible for non-UPC patent validations and national patents obtained in any national patent office. The difference here lies in this middle bit here, where we're looking at traditional validations of European patents in UPC member states. And for those traditional validations, there is a mixed jurisdiction between the national courts, as you would expect, and the UPC at the same time. That means, in other words, that you could bring proceedings in the national courts if you so choose, or through the UPC. Equally, you could be attacked in the national courts or through the UPC. Now, this is a transitional provision, and it is this arrangement here is not set in stone. The default situation is that, yes, all national validation in UPC member states fall under this mixed jurisdiction, but you can choose to opt your national validations out. And that really is quite an important procedure and an urgent procedure for reasons that I explain or try to explain at least now. So if you wanted to avoid this mixed jurisdiction that we've just seen on the other slide and go back to the sole jurisdiction of the national patent courts, also over your national validation of a European patent in UPC member states, you'd have to opt your national validators out of the UPC systems. A couple of points to note here. First of all, the default position is this one here. So if you don't do anything, your patent validations are subject to mixed jurisdiction by default. There's no choice. So you have to take an active step of opting your patents out to get the sole jurisdictions of the national courts for your validations. Now, that is not possible anymore, either when the transitional period is over after the end of those 7 years, or indeed if court action is already pending in either the national courts or the UPC, in which case you're stuck with whatever forum that court action has started. So really, you can't say, oh, somebody's attacking me at the UPC, I don't like it, let's opt out. No, if you came to that point, it would be too late. So that's an important point. The other important point is that you can opt out once, and you can withdraw your opt-out to get back to this mixed jurisdiction, but only once. Once you've withdrawn your opt-out, you're stuck with the mixed jurisdiction for better or worse. Maybe that's what you choose to do, fine. But if not, then there is no way back to this point here. Let's talk, a final point, of course. Once you've opted out, that state stays the same for the life of the patent. So what happens is, after the 7-year transition period is over, you still benefit from the opt-out until the patent runs to its end of its term. So it doesn't then automatically default back to the UPC. No, it doesn't. It actually stays with the national courts. That's important. Now, all that's well and good, but do you really want to opt out, or maybe you want to stay opted in? There are some advantages and disadvantages associated with the UPC. Let's deal with the disadvantages quickly. I think the main fear, I suppose, might well be that you might lose your national validations in a whole number of validation states through a single UPC court action. So there's a risk of central revocation. Also, the UPC is a new court with new rules of procedures. It's simply untested. So there will be a degree of uncertainty coming with the advent of this new system. Some will welcome that, others might well not. Conversely, there are advantages associated with the UPC. You can, for example, bring an infringement action that covers a number of countries. You don't have to go after an infringer in multiple court actions. So that should be simpler and more cost-effective. A few years ago, there was a call for applications for the job of judge, and a very positive development there was that the judges that have actually applied, there was an oversubscription, and the judges that have applied were actually very high quality. So that is quite a good omen for the future of this court. Now, if you are unsure if you should opt in or opt out, I think it's time to discuss this matter. We're more than happy to help you with this in as far as is desired. Now, 2 more comments really. As I said earlier, you can't actually opt out after court proceedings have started. Now, the makers of this system are well aware of it, so they have created a system where you can opt out before patent cases or court cases can be brought. The opt-out is possible from the start of the sunrise period, 3 to 4 months before the UPC system will actually come into force. And our recommendation to all our clients must be and is, if you wanted to opt out, if you're certain, then do it in that time period, because as soon as the courts come online, somebody can attack you and you might lose the ability to opt out. Now, the second point here is that the opt-out must be filed and can only be filed by the true proprietor of the patent. What that means really is 2 things. First of all, the registered proprietor may well not be the true proprietor. I think we're all aware of situations where the register does not accurately reflect the true proprietor of a patent. Now, if you were to consider a situation where the incorrect proprietor requests an opt-out, then that opt-out very simply can be invalid. And whilst you may think that you can only be attacked in national courts rather than the Unitary Patent Court, that may well not be the case, and you're still vulnerable to a central revocation attack. So whilst it might look like there is a lot of time left until the UPC comes into force, a lot of time left for the opt-outs, if the cleanliness of a chain of title has to be considered, there isn't really that much time at all. Additionally, I would urge you to not leave the opt-outs to the end of the sunrise period, for the simple reason that we expect many people will actually try and opt out. Then there is a question, will the computer systems actually be able to take it? And additionally, an opt-out is only valid once it is registered on the relevant register. There's an administrative step required to get it on that register that is out of the control of the applicants. And there is at this point no knowing how long that actually takes. We would suspect that the more people opt out, the longer it takes, so that at the end of the sunrise period, things will get really quite busy. There will be the option to bulk opt out many patents in a bulk process, and we are actually building an interface to allow such a bulk opt out should that be of interest. Now, the last point on UPC versus national validations is cost. How much is it going to cost me to do this? Now, the graph that you see here is annuity fees only. So it does not cover the costs of getting a unitary patent in the first place. It doesn't cover the costs of validation either. They would be on top here. There has been a big wrangling over the costs, the annuities for a unitary patent, and where we ended up is that the annuities payable for a UP are roughly the same as 4 validations in Europe. So if you're a company that validates in more than 4 countries, then in terms of annuity payments, the UP will be cheaper. If you only validate in 1 or 2 countries, then national validations will be cheaper. One thing that's not shown in this graph here is that if you were to validate nationally, then maybe as your patent ages, you lose interest in certain jurisdictions, and on a traditional validation process, you just drop those countries. You selectively prune your portfolio. You can't do that with the UP. Either you have protection or you don't. And if you do, you pay the full annuity fee. I think that's all I wanted to say on how to get unitary protection. I know there's a lot that I had said. If there are questions, please put them in the chat. And of course, we're also contactable. The contact details are at the end of this presentation. Thank you. Back to you, Graham.
Thank you, Thomas. What I'm now going to do is spend the next few minutes giving a brief overview of the structure of the Unified Patent Court. This slide here is a schematic, and what you can see is that there are 2 levels for this court, the Court of First Instance and the Court of Appeal. And there is also, in a dotted box at the top, CJEU, Court of Justice of the European Union. Now, what I want to be clear here is that most cases are not expected to go further than the Court of Appeal. It is the fact that the UPC applies European Union law, and therefore both the Court of First Instance and the Court of Appeal can refer questions of European Union law to the Court of Justice of the EU for determination. So this might arise if, for example, an alleged infringer raised a competition law defense to the infringement allegation, and as a matter of EU law, this required interpretation by the CJEU. When it comes to the substantive law of patent validity and patent infringement, it is not expected that the CJEU will be involved in that, and therefore the majority of cases should not progress further than the Court of Appeal. What we can see when we look at the bottom is that the Court of First Instance is made up of many different divisions. There's the central division, the regional division, and local divisions. The situation there is that any participating country in the UPC is entitled to have its own local division or divisions. Germany is planning to have 4. It's also possible for a number of participating countries to club together and have a regional division, which is essentially just the same as a local division, but covers more than one country. The central division is very important because of the work that will go there. I will come back to that later. And there was a lot of debate and a lot of negotiation over where the central division would be located, which ended with the parties deciding that it would be located in Paris, but that there would be branches in Munich and London. However, with the UK leaving the system, this means that there is an unanswered question as to, well, what will happen with the London branch of the central division? And that question has not yet been answered. So at first instance, lots of different divisions. On appeal, there is a single court of appeal in Luxembourg, and this court will be able to hear appeals on both substantive legal matters, such as infringement and revocation, and also on procedural matters. And what is very important about the fact that there is only one court is that this should result in proper harmonization of law and practice of the UPC across all divisions, because over time, even if initially we see local divisions in different countries taking different approaches, for example, to preliminary injunctions, we would expect the Court of Appeal over time, as it hears more and more cases, to set down guidance on procedural matters, for example, and rules on the law on substantive issues that will then be followed by all the first instance divisions. Right. I'm going backwards. Now I'm going forwards. Right. So a little bit more on the first instance divisions. The judging panels, because there will be more than one judge sitting in each division, there will always be at least 3 and sometimes 4 judges on a panel of a local division. And this will equally apply to regional divisions. The panel of judges will be multinational. So that's one important thing to remember, that even if you are in France, that does not mean that all your judges will be French. The panels will always be multinational. The plan is that where you have jurisdictions that already hear lots of patent cases and therefore have judges who with plenty of experience of hearing patent cases, 2 of the 3 judges on a local division will be, these will be 3 legal judges, will be local, so to speak, therefore of that jurisdiction, but there will be 1 additional judge of different nationality. If you're looking at a country which doesn't have such a developed patent court regime, then there will be 1 local judge and 2 other judges of other nationalities. In the local divisions, the starting point is that you will have 3 legal judges, and that could be increased to 4, in particular if there is a counterclaim for revocation of the patent and the local division decides that it will hear that counterclaim, then it will appoint a technical judge to the panel as well. The language of the proceedings is something that can be determined by the country hosting the local or regional division. That can be a language of the host state, or the host state is also able to approve the use of languages, the official languages of the EPO, so English, French, or German. And the countries that are currently proposing to host local divisions, I listed it on the previous slide, will have all so far said that they will intend to have English as an official language. There's one exception, Slovenia which only from last Tuesday this week, has said that it intends to have a local division. I don't know myself for sure whether it plans to also approve English. I suspect it will. So we can expect to have lots of English in the local divisions. Cases that are being heard in the central division will have a slightly different makeup of the judging panel. The starting point is that there will be 2 legal judges and 1 technical judge. It will again be a multinational panel of judges. The language of proceedings is determined by the language of the patent in suit. And in practice, that means that the vast majority of central division cases are likely to be heard in English. So again, we're expecting to hear a lot of English in this new court. The work of the central division is divided between 3 branches. That was what was originally provided, but without London, we don't quite know what's going to happen. It could be that another country is going to be hosting a branch of the central division. For example, Italy has been put forward as a possibility, also the Netherlands. Another possibility is that the work that would have gone to London will just be split between Paris and Munich. So that is ultimately going to be a political decision for the participating countries, and that is something which I assume is going to be determined during this provisional period that we're currently in, and certainly before the start of the sunrise period. It would seem very strange indeed if it went further without that question having been resolved. In the meantime, you can see that in terms of deciding whether or not to opt out of patent, if you don't yet know where your cases might be heard, that may be one reason that would point towards opting a patent out, at least until these questions are answered. But we may find that it already has been answered before the sunrise period starts, and then at least we'll be able to make informed decisions. There are a very, very large number of procedural rules. The rules of procedure, hundreds of pages, and don't worry, I am not planning to go through all of those now. I'm just going to talk about some of the most important, and starting with where actions will need to be brought. The simple rule to approach this is that a patentee wishing to bring an infringement action needs to start that action in a local division or regional division. This immediately means that if we're dealing with an infringement that might involve products that have been placed on the market throughout the European Economic Area, and therefore, by definition, in all participating UPC countries, this immediately will give the patentee a very, very large choice of where to bring the case. It could be that in that circumstance, it could be any local division or the regional division that's been proposed. The issue is, where is the infringement occurring? Or alternatively, where is the defendant domiciled? Now, if the defendant is not domiciled in the European Union, then the patentee can bring a case in the central division. It's also possible to bring the case in the central division if there is an infringing act in a country that is not itself hosting a local division or part of a regional division. So Luxembourg and Malta are 2 examples. If there's an infringement occurring in Luxembourg, the patentee can bring the case in the central division. Very important in terms of the negotiations, and also just thinking about patent strategy, is what will happen if the alleged infringer brings a counterclaim for revocation. This happens in the vast majority of patent actions, but very, very importantly in European patent litigation, it's well known that in Germany, there is what is called bifurcation, in that German procedural systems require the revocation action to be brought in a different court to the infringement proceedings. And that means that you can get a different timeline for the validity proceedings to the infringement proceedings. And there was a lot of discussion as to whether a similar arrangement would happen with the UPC. Well, it's something in between, in that there is no requirement to bifurcate. Like the vast majority of jurisdictions, validity proceedings can be brought in as a counter in the same court as infringement proceedings here in the UPC, and it will be possible for a defendant to counterclaim for revocation of the patent in suit. What will happen is that the local or regional division then has to make a choice. It can hear the infringement and revocation parts of the proceedings together, and that's likely to happen in the majority of cases, just judging from comments that have been received from likely judges in this court in the past. The local division could choose to bifurcate, and that means it would continue to hear the infringement case, but the revocation counterclaim would be sent for determination to the central division. However, if the local division decides to do this, it must decide whether or not to stay the infringement proceedings until the outcome of the validity counterclaim is known. And it must stay the infringement proceedings if it believes that the revocation action has a high likelihood of success. And this decision will be made when all the written pleadings have been filed with the court, so it will be quite well informed as to the arguments that are going to be raised on validity. It's also possible for the parties to agree that both the infringement and the revocation cases go to the central division for determination. If you're bringing a revocation claim, then you must bring it before the central division. And which branch will depend on the subject matter of the patent, and I'll be showing you a table on that in a moment. The patentee then has the option of bringing an infringement counterclaim, and the patentee again has a potentially very wide choice, because if the patentee wishes the same division to deal with both validity and infringement, then it can bring the infringement counterclaim in the central division. Or as I previously discussed, if there is an infringing act in another jurisdiction or the defendant is domiciled in another jurisdiction, it can bring the infringement counterclaim in the relevant local or regional division. Declarations of non-infringement, like revocation actions, these must be brought before the central division. However, there is a 3-month time period when the patentee has an option of commencing infringement proceedings, and if the patentee does so, the central division will stay the declaration for non-infringement proceedings, and the infringement proceedings will proceed and therefore in effect take precedence. And of course, there could again then be a counterclaim for revocation. Now, what this means is that if you are trying to clear the way by applying to revoke a patent that is potentially blocking a product from the market, a potential infringer would be very well advised to bring the declaration for non-infringement proceedings well over 3 months before it actually planned to launch its product, because it won't be possible for the patentee to bring an infringement counterclaim or bring an infringement action if there is in fact no infringement or not even a threatened infringement. So if there are no infringing acts occurring or threatened when the D&I proceedings are started, the patentee at that point won't actually be able to bring an infringement action elsewhere, and that will mean the declaration of non-infringement proceedings will proceed in the central division. So that's quite an important point where parties need to clear the way. 2 more slides. First, this is the split of cases in the central division. It was done by patent classification, and therefore if you're planning to revoke a patent, you will be able to determine, well, be able to see very easily which branch of the central division would hear this revocation action. Now, A and C, which are very, very important because they cover a very wide range of technologies, such as medical devices, as pharmaceuticals, biotechnology. those cases would have gone to London. And so, as I said before, there's a very big question mark as to who will be hearing those cases in the future. We can see that Class F, which involves mechanical engineering and is very important for the automotive sector, those cases will go to Munich, and all other categories, which including classes G and H, and therefore very important for telecommunications cases, would be heard in the Paris branch of the Central Division. Final slide. I'm not going to spend a lot of time talking about this, but this will be a useful reference slide as it sets out an example for how cases can proceed in the UPC. What you can see is that there are essentially three main strands to litigation that will proceed in parallel: infringement, revocation, and as a response to a revocation claim, very often the patentee may choose to apply to amend the patent. Now, for each of these, it is envisaged that the parties on either side will each have two written pleadings. So a claim, a defense, a reply, a rejoinder. And that can happen for, so 4 pleadings for infringement, 4 for revocation, 4 for amendment. That will end what is known as the written procedure. There will then be an interim conference where the judge rapporteur on the panel will decide what needs to be done to prepare the case for trial. That's the interim procedure. After that, the final stage will be the oral hearing. The rules of procedure intend the entire case to last around 12 months. It seems quite possible that it may take somewhat longer than that, and it will be very interesting to see if such a fast, or compared to other jurisdictions, and compared to the current participating countries' national jurisdictions, which could be a lot slower, it'll be very interesting to see if that's still going to be possible. My final comment is, what this means is within the UPC, and then also between the UPC and national courts, there are a vast number of choices as to where to litigate and how to litigate. And it means that for patent practitioners and their clients, patent strategy is going to need to be thought out very carefully indeed for future European patent proceedings. That brings us to the end of the webinar. So thank you all for taking part. It's been wonderful to have you here today. As you can see on this final slide, we have a UPC hub on our website where you will be able to get lots more information about unitary patents and the UPC. We're also going to follow up on any questions that you have, and we'll also be very happy to make a PDF of these slides available too. So thank you again very much indeed.